right now, sitting in a storage unit somewhere in Massachusetts, there are these two massive 4,000-pound bronze statues just sitting in the dark.
Yeah, completely paralyzed.
Right, and they were supposed to be the crowning architectural elements of this huge $800,000 municipal project. But instead, they're held up not by a lack of funds or, like, a construction delay, but by a court injunction.
Driven by just 15 local residents.
Exactly, 15 residents and a massive legal battle over the state constitution. And tomorrow morning, exactly tomorrow, May 6th, 2026, at 9:00 a.m., sharp a high-stakes hearing begins at the Massachusetts Supreme Judicial Court. They're going to decide if those statues will ever see the light of day.
This is your final essential briefing. You need to get fully up to speed before the trial actually starts tomorrow.
Because what happens at 9:00, it isn't just about a single building project in one city, right?
No, not at all. It is a defining legal showdown. It's about how local communities are allowed to express their history, how municipal art is procured, and really how the courts balance the highly subjective feelings of a few citizens against the actual historical intent of a local government.
Right. Because this is a perfect case study in how local community progress and civic pride can get stalled by, national divisive legal tactics.
It's a fascinating constitutional puzzle, honestly. And to really understand it, we have to start by setting the scene. So we're in the city of Quincy, Massachusetts.
The city of presidents.
Right, the city of presidents. And recently, Quincy built this brand new state-of-the-art public safety headquarters to house their police and fire departments. And to honor those first responders, commissioned two 10-foot-tall bronze statues for the front facade of the building.
And these are like very specific historical figures. Right?
Yeah, they are. One figure is Florian, who was a 3rd-century Roman soldier famous for organizing early firefighting brigades. And the other is Michael the Archangel, a figure associated across all sorts of historical texts with defense, justice, and, protection against evil.
But almost immediately, those figures became the center of a total legal firestorm.
Oh, yeah. Huge controversy.
Because the plaintiffs, which is that group of 15 local residents, backed by national organizations like the ACLU and the Freedom from Religion Foundation, they filed a lawsuit. They pointed out that the Catholic Church, along with several other traditions, revere these figures as St. Florian and St. Michael.
Right.
So the plaintiffs argue that placing these figures on a public safety building is basically a clear-cut case of the government endorsing Catholicism and crossing that line between church and state.
Which led directly to the roadblock we're looking at right now. Because in October 2025, after the city had already spent, get this, over $760,000 on the project.
Oh, wow.
Yeah, Judge William P. Sullivan issued a preliminary injunction. He just halted the installation dead in its tracks. He ruled that the statues couldn't go up while the civil case was actively being litigated.
Okay, let's unpack this from the city's perspective. Because as a local taxpayer who values city history and civic symbols, you kind of have to wonder how digital noise and personal feelings are being used to tie up municipal leadership. If this is ostensibly just municipal public art, how did 15 residents manage to secure a legal injunction to stop such a massive project?
Well, you have to look at what exactly they're claiming is the harm in their lawsuit.
Right, what's the actual injury?
When you look at the plaintiff's brief, it is heavily focused on the subjective personal experience of the residents. It relies significantly on sworn declarations from those 15 people.
What are they saying in the declarations?
They describe this very real emotional toll they believe the statues will take. They state that knowing these figures might go up makes them feel alienated or deeply offended or like second-class citizens in their own town.
Wait, really? Over a statue of a historical firefighter?
Yeah, one resident specifically argued that just walking past the statues to use the police station's drop box for old prescription medications would cause them, and this is a direct quote, negative concern.
Negative concern.
Right. And furthermore, they presented a Change.org petition with about 1,600 signatures to try and demonstrate to the court that there's this significant public outcry against the project.
But the defendant's brief, the city's brief, counters this narrative by focusing on tangible evidence, right? And the actual legal definition of harm. Because the city argues that just feeling uncomfortable viewing a piece of passive civic art does not equate to a constitutional violation.
Exactly. The city points out that nobody is being denied police or fire services based on their religion, right? Nobody is being treated differently under the law.
And the city draws a very sharp distinction between religious idols and internationally recognized professional symbols.
They do. Their brief provides extensive evidence about the culture of first responders. They note that police officers all over the country frequently have, like, portraits of Michael the Archangel tattooed on their arms, or they carry challenge coins with his likeness.
Yeah, and firefighters universally celebrate May 4th, which is historically tied to Florian.
Right. When a firefighter tragically dies in the line of duty, it's this deeply embedded tradition in the fire service to say they have gone to rest with St. Florian.
You know, that makes me think of a real-world analogy. If a city builds a public hospital and names it St. Jude, it isn't executing some secret plot to convert patients to a specific religious denomination.
Obviously not.
No, it's invoking a universally understood cultural symbol of healing and hope. Why should police and fire symbols be treated any differently? The city was basically arguing that these figures should be treated exactly the same way as cultural touchstones for bravery and sacrifice.
And if we connect this to the bigger picture, this kind of mirrors a national tactic where small groups use litigation to attack local leadership and just stall civic progress. Which brings us to a major point of contention in the briefs: the accusation of secrecy.
Ah, right, the secrecy claim.
Yeah. The plaintiffs, and frankly the lower court judge who issued the injunction, they placed a lot of weight on the fact that the mayor didn't run the specific statue designs by the city council or the public during the early stages of the building's development.
So the plaintiffs are framing this as, what, a clandestine, backroom religious plot kept hidden from taxpayers.
Pretty much. But the city's brief pushes back hard on that characterization. And they do it by explaining the actual mechanics of municipal construction. They used a procurement method called construction manager at risk.
CMR.
Right, CMER. It sounds like jargon, but it's incredibly common for big government projects.
Yeah, I actually had to look this up. Essentially, a city hires a construction manager during the design phase, and the manager guarantees a maximum price for the whole project.
Which protects the taxpayers from cost overruns.
Exactly. But to do that, they have to start building before every single aesthetic detail is finalized.
Right. It intentionally provides flexibility to finalize design features late in the process. Think of it like building a custom home. You sign the contract with the builder to pour the foundation and frame the walls so you can lock in the price of lumber, right?
So,
But you might not pick out the specific cabinet hardware or the front door color until months later.
right. So the mayor was working with the architect on the final design features of the front facade long after the initial building had been approved. It wasn't a secret plot. The city argues this was simply the mayor exercising his standard executive discretion over public art, completely within the legal bounds of a CMR contract.
And this raises a crucial question for you to consider as a listener. I mean, imagine you're a city leader. The city of Quincy is arguing that if courts allow online petitions and subjective declarations of personal alienation to just override standard, legally executed municipal contracts, that sets a dangerous precedent.
Right. So what does this all mean for taxpayers? Are we saying that a vocal minority can use an online petition to veto community art just because they personally take offense to it?
Their brief suggests that this would transform constitutional law into exactly that, a mechanism where any vocal group can cancel public projects based on feelings.
I hear that, but let's play devil's advocate for a moment. Couldn't the plaintiffs argue that a statue of a saint is inherently religious, regardless of the mayor's intent or the construction contract? Like, how does state law actually handle the presence of religious imagery on government property?
Well, that is precisely where the city's brief leans heavily into historical precedent. Because if the plaintiff's standard for personal offense were strictly applied as the law of the land, what would happen to the rest of the historical monuments in Massachusetts?
They'd all have to come down.
Exactly. The city points out that religious imagery is embedded in government buildings everywhere, functioning as historical or professional symbolism. The brief references the depiction of Moses at the U.S. Supreme Court, the monument to Mother Cabrini in New York, and the marker for Pope John Paul II in Boston.
But the most striking example they give is literally inside the building where tomorrow's hearing is taking place.
I know, it's wild.
Inside the Massachusetts Supreme Judicial Court's own courthouse, there is a statue representing religion that is physically holding a Bible and a cross. The city is asking, How can the plaintiffs argue that Quincy's statues are unconstitutionally endorsing religion while they literally argue their case in a building adorned with a statue holding a Bible?
What's fascinating here is that it forces us to look at the exact text of the law. The plaintiffs claim these statues violate Article 3 of the Massachusetts Declaration of Rights. But to understand Article 3, we have to look at the mechanics of why it was written.
The history.
Right. The city's brief dives deep into the history, going all the way back to 1833.
What was happening in Massachusetts in 1833 that prompted this?
Well, at that time, the Congregational Church was essentially the established church of Massachusetts.
Yeah.
Tax revenues were being legally collected and used to directly pay the salaries of Congregationalist ministers. So if you were a Baptist or an Episcopalian, your tax dollars were being forcibly taken from you to financially support the leaders of a different church. Yeah. That is what the framers meant by subordination. Article 3 was amended specifically to stop targeted, direct financial assessments that supported one religious sect over another.
So the law was engineered to stop the government from forcibly taking your money to pay a priest's salary.
Yeah.
The city's argument is that Article 3 was never meant to force a massive, iconoclastic stripping down of passive public art.
Exactly. That is the crux of the historical argument. The legal distinction here is between actual legal subordination and simply feeling uncomfortable viewing a statue.
Right.
Article 3 states that no subordination of any sect shall be established by law. The city argues that placing a bronze statue of a Roman firefighter on a wall doesn't change anyone's legal rights. It doesn't legally subordinate an atheist to a Catholic. It doesn't change their duties or deny them equal protection.
Which makes sense, because if the court disagrees with the city and sides with the plaintiff's interpretation of Article 3, it would logically mean taking a sandblaster to half the historic monuments in Massachusetts.
Yeah, pretty much.
So, knowing the history of the Constitution, let's look at the specific legal tests the SJC will be using tomorrow morning at 9:00 a.m. to make their decision. Because the two sides are relying on completely different legal frameworks.
This is where the briefs get incredibly technical, but it's honestly the most important part of the case.
Right.
The plaintiffs have relied heavily on a federal precedent known as the Lemon Test. For decades, the Lemon Test was used by federal courts to determine if a government action violated the establishment of religion. And one of its main features was asking whether a reasonable hypothetical observer might feel that the government was endorsing a religion.
But there's a massive complication with the plaintiffs relying on the Lemon Test, right?
Oh, a fatal complication, according to the city's brief. The United States Supreme Court has explicitly abandoned the Lemon Test.
They threw it out.
Entirely. In recent rulings, like Kennedy v. Bremerton, the Supreme Court threw it out because it was completely unworkable. I mean, asking judges to guess what a hypothetical, easily offended observer might feel, it just led to wildly inconsistent rulings and an unfair hostility toward religion in the public square. So the city points out that the plaintiffs are resting their case on a discarded federal precedent.
Here's where it gets really interesting. Meanwhile, the city is standing firmly on state law. They argue the Supreme Judicial Court should use its own gold standard, which is a 1979 Massachusetts case called Colo v. Treasurer and Receiver General.
Right, and in the Colo case, the court actually upheld the use of public funds to pay legislative chaplains to open government sessions with a prayer.
So wait, let that sink in. The state's highest court has previously ruled that it's constitutionally permissible to use taxpayer money to pay an actual living religious figure to say a prayer in the legislature.
Exactly, and in that case, they established a 4-factor test to evaluate these situations: purpose, effect, entanglement, and divisiveness. The city of Quincy's brief methodically applies all 4 of these Colo factors to show why the statutes are perfectly legal.
Okay, let's walk through how those factors actually work in practice. The first is purpose. Looking at the city's brief, this seems pretty straightforward. Mayor Koch provided sworn affidavits stating his purpose was entirely secular, to honor and inspire first responders, boosting morale with internationally recognized professional symbols.
Right, and the court looks for a valid secular purpose. The second factor is effect. Does the primary effect of the action advance religion?
Right.
The city argues that the statues are passive architectural elements. There's no signage directing anyone to pray to them. They don't block or overshadow the entrance to the police station. Their primary effect is conveying dedication, justice, and courage.
And the third factor is entanglement. And looking at the briefs, this seems to be where the city draws a hard line between a static piece of bronze and active government overreach.
Yeah, entanglement asks if the government is getting overly involved in religious affairs. Let's use an analogy. Think of the difference between a landlord-tenant relationship and simply hanging a painting on a wall.
Okay.
If a city subsidizes a church, they have to constantly monitor the funds, audit the books, and engage in an ongoing relationship. That is a landlord-tenant level of entanglement. But erecting a statue requires zero ongoing monitoring or regulation of religious activity. Once the 4,000 pounds of bronze are bolted to the steel supports, the transaction is over.
It's infinitely less entanglement than employing a chaplain on the state payroll, which the Colo case already permitted.
Exactly.
Which brings us to the final factor, divisiveness. Now, the plaintiffs point to their lawsuit and the petition as proof that the statues are tearing the town apart and are therefore unconstitutional.
But the city counters that this divisiveness is entirely manufactured by the plaintiffs themselves. I mean, the legal argument here is that you cannot file a lawsuit, generate a media campaign, circulate an online petition, and then point to the controversy you just created as proof that the original project is unconstitutional.
Right, that's circular logic.
Totally. And the city notes that the first responders themselves, the actual police and fire unions who will use the building, they are completely united in their support for the statues.
So we have a clear view of the battlefield for tomorrow's hearing. The plaintiffs are asking the court to focus on the subjective emotional distress of residents and to apply a standard similar to the abandoned federal lemon test.
While the city is asking the court to look at the objective historical facts, the standard municipal construction contracts, and the act of state law of the Colo test.
It's a profound conflict between modern subjective grievances and objective historical reality.
Yeah.
Tomorrow morning, the Supreme Judicial Court has to decide which standard governs the Commonwealth of Massachusetts.
Which really brings us to the ultimate stakes of this deep dive. Imagine you are a taxpayer or a local leader anywhere in the state. This case is fundamentally about whether Massachusetts will uphold the city's right to honor its community with permanent civic monuments using standard executive discretion.
Or if it will validate a legal tactic where a small group of citizens can halt a massive, heavily funded municipal project based on personal feelings of alienation.
If the court rules in favor of the plaintiffs, it sets a chilling precedent.
Yeah.
It means that every mayor, every city council, every community planning committee in the state will have to second-guess every piece of public art. They will have to ask themselves, will a hypothetical observer find a way to be offended by this? It changes the entire landscape of local control.
And that is why tomorrow is so critical. The hearing begins tomorrow, May 6th at 9:00 a.m. You are now fully briefed. You understand the mechanism of CMAR construction contracts. You know the 1833 history of Article 3. You understand the difference between the abandoned lemon test and the state's Colo precedent, and you know exactly how both sides have built their arguments. You are ready to watch this unfold, knowing exactly what's going on underneath the headlines.
But before we sign off, we want to leave you with a broader philosophical question to ponder, something that goes beyond the legal briefs and touches on the very nature of our public spaces.
Think about the concept of a shared community heritage. If we allow the highly subjective feelings of a few citizens to legally erase historical and cultural symbols from the public square, what happens to our shared spaces over time? Can any meaningful civic monument survive if the new legal standard for public art is that it must offend absolutely no one? When the gavel strikes at 9:00 a.m. tomorrow, the judges won't just be looking at a dispute over two bronze figures. They will be deciding the future baseline for how we are allowed to publicly remember and honor our own history. Keep your eyes on Quincy.